Here's the problem. You think you have a solid business partnership. You've shaken hands, split the work, maybe even filed some paperwork together, right? But if I were the attorney sitting across from you in court, I could destroy your entire partnership agreement in just about 20 minutes, because here's what's happening. You're running a business with someone based on conversations, assumptions, good intentions. You think that makes you business partners, but legally, you might have nothing. I'm Karam Nahas. For 20 years, I've been the attorney hired to dismantle business relationships that people thought were rock solid. I've destroyed partnerships worth millions of dollars using nothing but basic legal principles, careful questioning, and diving right into your business. So today, I'm going to show you exactly how I would do that to your partnership so you know how to protect it, because here's what's at stake. Everything you've built together, your business, your assets, your future profits, when someone decides they want out or they want more, these are the weapons they'll use anything and everything against you. So I'm going to walk you through my exact litigation playbook for attacking informal partnerships, not to scare you, but to show you what you're up against and how to protect yourself before it's too late. That's what it means to be legally bulletproof. So while this might be a little uncomfortable, it could save you everything that you've worked so hard for. So here's attack number one. Prove that the partnership exists, right? Here's your problem. You think that your handshake deal and verbal agreements prove you're business partners. But in court, I don't have to prove you're not partners. You have to prove that you are. So here's how I would attack this. Your Honor, where's the partnership agreement? Where does it say these parties intended to share profits and losses equally? Where does it say they intended to bind each other to business obligations? Now here's going to be your rebuttal. But we've been working together for 3 years. We split everything 50-50. We both make decisions. I would destroy that, and this is how. Your Honor, that describes an employment relationship, not a partnership. My client was clearly the employer, and the plaintiff was working as an independent contractor or employee of my client. The fact that he was paid, well, that doesn't make him a business partner. And why this usually works is that most informal partnerships look exactly like employment relationships or contractor arrangements. Without written proof of your intent to be business partners, I can reframe your entire relationship as something else. So the legal reality is partnership law requires proof of mutual intent to carry on business together with shared profits and shared losses. Your assumptions about what you agreed to aren't evidence. So here's attack number two, no meeting of the minds. What's your problem? You think that you both understand the deal the same way, but you never wrote down the specifics, so you're both guessing about what you actually agreed to. How am I going to attack this in court? I'm going to say, Your Honor, there's no meeting of the minds here. They never agreed on basic partnership terms. Who owns what percentage? What is each person's specific roles? How are decisions made? How are profits distributed? When someone can leave? And what are you going to say? Well, we discussed all of that. We both understood we're 50-50 partners. I'm going to destroy that. Because if that's true, why did my client handle all the financial decisions? Why did my client sign all the contracts? Why did my client's name appear on all the business licenses? Why was the business bank account just in my client's name only? The cross-examination that you would face would be intimidating. When exactly did you agree to be 50-50 partners? What month? What day? Who said what words exactly? Was anybody there to be a witness? Do you have any emails confirming this agreement? Any text messages? Any witnesses? And why does this usually work? Because without written terms, I can point to dozens of actions that contradict your claimed agreement. Every business decision one person made without the other becomes evidence against equal partnership. I used to do this all day long. Now here's attack number three. It's called the statute of frauds. It's a little bit of a complicated legal doctrine, but I'm going to explain it to you simply. What's your problem? Many states require certain partnerships to be in writing, especially if they involve real estate and they last longer than 1 year or involve significant assets. So how am I going to attack this in court? I'm going to say, Your Honor, this alleged partnership violates the statute of frauds. The plaintiff claims that they had a multi-year partnership agreement involving real estate and significant assets, but state law requires such agreements to be in writing. Since there's no written agreement, there is no partnership. It's legally null and void. What are you going to say? But we've been operating a business for years. You can't just ignore our business relationship, course of conduct. I'm going to destroy that because the statute of frauds exists precisely to prevent people from claiming business relationships that were never formally agreed to. So if the plaintiff wanted legal protection, He should have insisted on a written agreement, right? His failure to do so means he has no enforceable rights, or they never intended to be legally bound that way. So there's a big legal trap here. Even if you can prove that you had some sort of business relationship, I can argue that your specific claims about ownership percentages, profit sharing, and decision-making authority are unenforceable without writing. Why does this often work? Because courts are reluctant to enforce major business agreements that violate statutory writing requirements. Your informal partnership might become legally meaningless, and this is a great argument. Now, attack number 4 is to recharacterize your business partnership as something else, right? Here's the problem. You think calling yourselves partners makes you partners, but I can reframe your entire relationship using different legal categories. This is how. Your Honor, this was never a partnership. This was a joint venture for a specific project that ended 2 years ago. Or this was a licensing agreement where my client allowed the plaintiff to use business resources. Or this was an employment relationship with profit-sharing bonuses. So what are you going to say? But we were building a business together, we both invested time and money, the same old stuff. And I'm going to destroy that because time and money don't create partnerships. Employees invest time, contractors invest resources, licensees pay fees, joint venturers work on projects. Without a written partnership agreement specifying the relationship, any of these characterizations fits the facts better than a partnership. It's all about reframing the legal issues before the judge, and that's what I was really good at, and that's what good litigation attorneys will do, and you'll probably lose because this usually works. Because your informal business relationship probably fits multiple legal categories. I just need to pick one that gives my client the most advantage and you the least protection, and the burden's on you to prove what you can't because you don't have a writing. So attack number 5 is called having unclean hands. Here's the problem. You're asking the court to enforce an informal agreement that you didn't bother to formalize yourself. So I'm going to say to the judge, the plaintiff is asking the court to create a partnership agreement that they never bothered to negotiate or document. They're asking for rights that they never secured. So this is kind of like unclean hands, right? So I'm going to say that this court should not reward such careless business practices. And you're going to say in rebuttal, but we trusted each other. We didn't think we needed a formal paperwork. And I would destroy that in court by just saying trust is not a legal substitute for documentation. If the plaintiff truly believed he was entitled to 50% of the value of the business, why didn't he insist on proper contracts? Why didn't he protect his interests? His failure to secure legal documentation shows that he understood this was not a formal partnership. That's how I would do it. And then I would attack further and I'd say, Your Honor, the plaintiff is now trying to claim rights to a business he helped build while refusing to acknowledge the legal obligation that would come with those rights. He wants partnership profits without partnership liability. He wants partnership benefits without partnership responsibilities. And this will often work because courts sometimes refuse to help people who didn't help themselves. So if you're asking a judge to create legal rights that you never bothered to establish, you might be seen as trying to take advantage of someone else's work. It's called unclean hands. It's a great defense, right? So what's the solution to all this nonsense? The reality here is everything that I just showed you is completely legal. These aren't dirty tricks. They're standard litigation strategies that work because informal partnerships are legally vulnerable. Put it in writing. What you need is a written partnership agreement that clearly establishes partnership intent and structure, ownership percentages and capital contributions, roles, responsibilities, and decision-making authority, profit and loss sharing arrangements, exit procedures, and buyout mechanisms. If you don't have these agreements, hit me up. I have them. They work. You need them. I can't attack what's clearly documented. When you have proper contracts, my entire playbook becomes useless. Instead of arguing about what you meant, we're just interpreting what you wrote. And a judge loves that. They love simple documents. So what's your next step? Stop operating on assumptions and start operating on agreements, because the entrepreneur across the table might hire someone like me to take everything you've built. And like I said, your business partner can become one of your biggest enemies. Now the stakes are high. I've just shown you how I destroy your informal business partnership using basic legal principles that any competent attorney knows. This isn't advanced litigation strategy. This is partnership law 101. So you have a choice. You can keep operating on handshakes and hoping for the best, or you can get some proper legal documentation that protects everything you're building. The real truth is that entrepreneurs who succeed long-term aren't the ones who trust everyone. They're the ones who trust proper legal structure to protect their relationships when emotions change. And your partnership might be built on friendship and good intentions now, but like I said, partners can become one of the worst enemies you'll ever see in business. Don't give someone like me the opportunity to destroy what you've worked so hard to build. So if you want bulletproof partnership agreements or to learn more, just DM me. I can help you. Now you understand what could happen in court. You need to understand how to legally bulletproof your partnership agreement from day one. That's the next video I'm recommending. Click the link below. I'm Karam Nahas, the battle-tested lawyer. Stay legally bulletproof. I really hope that you enjoyed this video, but if you're sick of guessing whether your business is exposed to legal threats you can't see or didn't know was coming, those enemies, mistakes, and liability that cause entrepreneurs to lose, then I've got something very special for you. It's my free business risk report, the same kind of analysis I charge $7,500 for in person when I do my business defense legal mastermind. Click the link below. Answer some strategic questions about your business and get a personalized risk report. You've got nothing to lose. Find out what's hunting you and your business before it destroys everything you've built. I'm Karam, the battle-tested lawyer. Stay legally bulletproof, please.